Hi everybody, I'm Dan Couts from Couts Buckley, and today we're going to talk about supplemental needs trusts. And the reason why I feel this is so important is because for the last 25 years, I've been the trustee and the guardian of my brother and sister. Unfortunately, they've recently passed, but this is still very important to me and our practice. Today, what I thought we would do is go over who needs a supplemental needs trust and why they need them. And then also we'll touch upon what type of supplemental needs trust would benefit your family or which one's right for you. First, let's talk about who will need it. Generally, anybody who's receiving entitlements such as Medicaid or Social Security supplemental income, also referred to as SSI. These are the individuals that are receiving this generally because of disability. And we want to use a supplemental needs trust in order to protect those entitlement programs, such as the Medicaid and the SSI. The reason why is because those entitlement programs are based on resources. And if you're watching this, there's a good chance that you've applied for one of these services. And what's happened is you may have gotten a letter that says you're over-resourced. Over-resourced in this context means that somebody or the beneficiary of the trust or the child receiving the entitlements either has substantial gainful activity, which means earned income up and beyond the amount of money that is allowed, or inside their Social Security number or held in their Social Security number are assets. Assets such as U.S. savings bonds, 529 plan. They may have been working at a local market such as Wegmans, who automatically gives profit sharing to the 401k, and then that grows to be more than $2,000. Things that you didn't think of, but all of a sudden pop when you file for one of these entitlement programs, and the child who you're filing for has too much money, over $2,000. Therefore, they're over-resourced. So that is who we usually set these supplemental needs trusts up for. This is why, and you want to look for what the term resource means in over-resourced, because that means we're going to have to lean on a supplemental needs trust most likely to qualify the individual to get one of those programs. I thought now would be a good idea to understand what public programs or public benefits we're looking for here. Off the bat, if you're an American citizen, you're eligible for Social Security disability insurance, and you're also eligible for Medicare when you turn 65. Those are funded through FICA, through our payroll taxes. The type of programs we're focused on when we're dealing with a child with disabilities or a loved one with disabilities are supplemental Social Security income, referred to as SSI, or Medicaid, which is an entitlement program based on the resources. Medicaid is usually the biggest important thing that we're going for here. The reason why, if you're like with my brother and sister, we needed wheelchairs, feeds, pumps, group homes, nursing. That's what Medicare pays for. We weren't too worried, or Medicaid, pays for. We weren't too worried about the supplemental income coming in. We were more concerned about their medical needs. These two programs are safety nets. They're entitlement programs that are going to be based on resources and funded by the federal government. Another way that recently have come to light is the self-directed program. That is also Medicaid dollars. It's just delivered to the family in a different way. But you still must fall under the resource limits in order to get self-directed or supplemental Social Security income or Medicaid. So understanding where these assets come from, in other words, they're coming from the federal government, and understanding how you qualify for them, making sure you're not over-resourced, is key, and that is why we use supplemental needs trusts. When you apply for Social Security supplemental income, I believe it's important that you contact an attorney. It's worthwhile to get the consultation here. Different attorneys, you're probably going to be looking for an attorney that specializes in disability law, elder law, something of that nature. So a very high overview, when you do apply for supplemental Social Security income, SSI, the Social Security Administration is going to have a questionnaire. Either you can do it in person or fill it out over the phone. You'll get an interview. And what happens is you're going to probably fall into one of these four categories. Living in the house of another is the lowest benefit. And it's going to vary from state to state, county to county, but that's the first level of SSI. and that means that you're living with mom and dad, and the questions are really going to revolve around shopping, food needs, shelter needs, stuff like that. Living with others is where you share costs. This gets a little more confusing or complicated, and it's something that I don't commonly see, but it is an option to qualify for SSI. Living alone is something that we have used for our families. This is where you charge your child with disabilities, you charge them rent, and you fill out a room or lodger agreement, and the child makes their mark, signs their name, and it does come up to be a little bit of a moral question. Am I going to charge my child rent to live in my house? But what that will allow you to do is able to increase the amount of money that's coming through from Social Security, SSI, in order to help cover some of the expenses. And if this child, you do this at the time when the child's age 18. So maybe it's a child that was not disabled. You were hoping that they're moving on and off the payroll at home, and this child with disabilities could be with you for quite a while. Therefore, you need a little extra help to cover the bills. Living in an IRA, this is a community residency or a group home. This is where it's the highest payout, and this is where the child with disabilities is living in a group home, and then you got to figure out who's going to be the rep payee. The representative payee, rep payee, is the person who is in charge of seeing the money get deposited into the bank account and distributions out of the bank account. What's important when a child with disabilities is receiving SSI, Supplemental Social Security Income, that money goes into a rep payee account at a local bank, and that account is under that child's Social Security number. So what you want to keep an eye on is that that account does not get more than $2,000, because at that point you're over-resourced and you could lose your SSI. So when you're the rep payee, is somebody who is identified to be the person who receives or oversees the account, you want to make sure that balance doesn't creep up. Who can be the rep payee, representative payee? It could be mom or dad. It could be the agency that runs the group home that the child's in, or it could be the recipient themselves. So this is something you want to identify and be clear and make sure that you keep an eye on the balance. What is a supplemental needs trust? These are irrevocable trusts, which means once the money is given to the trust, it cannot be taken back out. It's a completed gift. And that money inside, or the assets inside the supplemental needs trust, are clearly and only for the beneficiary of that trust. This trust must be made by an attorney. This is something you don't want to go online and I figured this out online and then we created our own supplemental needs trust. It's very important you consult a qualified attorney, one that deals in disability law, elder law, something of that nature, because there are very specific language and very specific rules to qualify the trust for as a supplemental needs trust. This will allow families to pass on pretty much unlimited amounts of money to the trust for the benefit of the beneficiary. An example of this would be mom and dad have some assets that are invested in a brokerage account, and upon their death they want the money, instead of going to their son who's disabled, whose name's Johnny, instead of going to Johnny directly, it will go to the trust for the benefit of Johnny. And the amount of money that can be held in the supplemental needs trust is unlimited. You want to be careful on how much you put in. You want to have a plan to how much you should put in for many different reasons, and we'll touch on that in a couple seconds in a few more slides. It also will allow you to put real estate into a supplemental needs trust. It could be a retirement account if it's left correctly to the supplemental needs trust. These are all things we go over when we plan with our families on how to implement them and how to use them. As I mentioned before, it's very important for our families and the kids that are disabled to make sure that they get the medical needs they need, such as that are supplied by Medicaid, that are also helpful when you have SSI. So you want to make sure you protect the entitlements. And that's why you use supplemental needs trust. You're going to get a letter that says, hey, I'm over-resourced, and you want to be able to move the money that is in our son who's disabled, named Johnny in this example, out of their Social Security number and put it into a supplemental needs trust under a different Social Security number, and now you're not over-resourced. So it protects the entitlements such as SSI and Medicaid. A supplemental needs trust can be used for just about anything. It gets complicated when you start using it for shelter and food in some cases. The reason why is because you already have entitlements coming in to supply for food and shelter, such as SSI and Medicaid. So what will happen is if the government sees somebody else is willing to pay that bill, what they will do is decrease the amount of aid they're giving you. And what that means is they're getting supplied some way. It's called in-kind support and maintenance. That means something else, in this case, the trust or a person, is willing to pay the bill before the government is. So what happens is if you use the trust for something that is considered in-kind support and maintenance, it could bring down how many dollars you get from SSI. So you want to be cognitive of how you're spending the money and what you're spending it on. This last part, this hits home. It protects the assets from a creditor. And what I mean by this is I know growing up, my family, my mom and dad turned to me and said, Dan, we're going to leave you some extra money to take care of your brother and sister. I said, absolutely, no problem. The issue there is, what happens if I get in a car accident or I get sued? That's money that's in my name, my social, and it's up for grabs for distribution. Or married and I get divorced, and it could go out the door on equitable distribution to my ex-wife there, which we hope will never happen. However, this is important because if the family's intentions is to leave money to another family member to support or help the child with disabilities, their brother or sister, if you run into these situations of getting sued or divorced, all of a sudden the money that was earmarked for your brother and sister is out the door. So using a supplemental needs trust, moving the money into the supplemental needs trust for the benefit of your brother or sister or your loved one, and then making the responsible person or the person you want to oversee that, the trustee, is the better way of doing things. Not leaving the money to the person directly, the brother, like in my case, to me, in hopes that I take care of my brother and sister. The better thing to do is to leave it to the trust and name me trustee. This is why we use a supplemental needs trust, and that's how they work. Who's involved? You're going to have the grantor. The grantor is the person who gives the money to the trust, sets it up. Who's giving the money? Who's funding it? The beneficiary will always be the disabled individual. They're the ones who will benefit from the services or the assets that are in that trust. You never give money directly to the beneficiary. You always pay for the goods and services. Because if you write out a check or give money to the child with disabilities, that's going to be considered in-kind support and maintenance, and you don't want to do that. The trustee is the person who's in control of the assets. As a financial planner, this is the person we work with all the time. We work with the trustee to make sure that the assets are placed in the trust the proper way, under the right titling. We talk about taxation, we talk about how it's invested, and we talk about how do you get the money out to pay for the goods and services or the needs for the child with disabilities. They're the ones that are also going to be filing all the documents for any court-ordered documents or any kind of accounting that might need to be done, and also filing the taxes. The courts and social services could be involved specifically if this is called a first-party trust, and we'll get into that in a slide or two. But the courts may have to approve the supplemental needs trust. They may have the right to audit it. They may have the right also to talk about how much gets distributed from the trust at any given time. So the trustee is the person that would be working with the courts, and this is why you'd like to work with an attorney that is very versed in this. This page, this is where all the notes are usually made. There are a couple other supplemental needs trusts and things referred to as ABLE accounts, but these are the three most common supplemental needs trusts that we work with and that we have our families use. I'm going to probably tell a story and then come back to the bullet points. So let's first talk about the Testamentary Supplemental Needs Trust. This is a type of trust that's built inside your will. You go see an attorney, and the attorney will build the will for you, but inside they'll put a couple paragraphs in there. And the paragraphs is what will create the Supplemental Needs Trust upon your death. How I tell clients to think about it is this. Think about the trust as asleep inside your will. And when you pass away and the will gets probated, the trust opens up. But when that happens, that trust opens up on the date and under the date and under the laws of that time. Let me put it a different way. When that trust opens up, what happens is it is now governed under the rules and regulations of that date. So it's a date in the future upon your death. How this trust gets funded is by beneficiary designation. In other words, mom and dad may not have a lot of money right now, or they're going to need the money to prepare for their retirement and their needs later in life. But what's ever left over, they want it to go to the trust for the benefit of their disabled son. And in these examples, benefit of my disabled son, Johnny. All right, so what will happen here is the parents will see the attorney, talk to him about what kind of, trust they would need. And at this time, a testamentary trust would serve them the best because it doesn't cost too much to set up. And there's really no assets here today, but they want to make sure that they leave something for their son who's disabled in the future. And these are good, but I find them to be a little bit of a stopgap, okay? The next type of trust is a third-party trust. A third-party trust is up to date. It is created the date you sign it. It is functioning the moment you sign it. So therefore, assets can go into it right away. And when you create a third-party supplemental needs trust, it has its own tax identification number. Why is that important? Because this is where you have a trustee. Let's use my family for an example. We set up a supplemental needs trust third party for my brother and my sister. They make me the trustee. I'm in charge of the money that goes in and how it gets invested and fill out the taxes and everything. And any needs or services that my brother or sister need, I write the check out to the service that provides it. I don't write the check out to my brother and sister. That way, it's not attainable assets. Any money in there, they can't get my brother and sister can't get their hands on it because they have to go through me. And it's under a different tax identification number, so it's clearly not their money. That's why it protects the SSI and the Medicaid. The other thing, too, is upon my brother and sister's death, because this was funded with private family money, or another way of putting it, this is funded by anybody other than the child with disabilities. Medicaid cannot put their lien against this trust. So when my brother or sister passed, Medicaid said, hey, we have a lien for all the services that we provided your family. And any money that's left in my brother and sister's Social Security number, Medicaid can grab that. And any money that is not, and let me put it this way, any money that is in the third-party trust, Medicaid cannot grab that because the beneficiary of the trust was not the grantor. They didn't give the money to this trust. That also goes for the testamentary trust, and I kind of forgot to mention that. At the death of the beneficiary, the death of the child with disabilities, any money left in that trust was funded with private family money. It was not funded by the child. Therefore, Medicaid cannot put a lien against the testamentary trust or third-party trust. Now, in the event that we're working with a family that their child with disabilities suddenly got money, either through a lawsuit settlement or an inheritance or winning the lottery, whatever way it is, the money actually landed in their son or daughter's pockets. And in this case, let's call it our son, Johnny, who's disabled. The money landed in Johnny's pockets. We must use a first-party trust. And that's because Johnny funded the money, funded the trust. A first-party trust, the way the money gets into it, it has to come from the beneficiary, the child with disabilities. Unlike these other two, are funded by anybody other than the child with disabilities. This one is funded by the child with disabilities. That means they won a lawsuit, unexpected inheritance, the lottery winner, stuff like that. All of those are true stories. And these are either funded by mistake or by lawsuit because the child was a plaintiff and won the case. Let me explain how these come about. We will suddenly get a call from either a family or an agency that says, hey, Johnny here, our individual with disabilities, we just realized he's got an over-resourced letter. He's too much money. And what happened was Johnny inherited money by mistake. Let's just say there was Aunt Ruth on the West Coast, wealthy, had all this money in stock and always wanted to take care of her nephew over here in the East Coast, over here in Buffalo. And what happened when she died, she said, I want to leave this money directly to Johnny. So she had every great intention. What she didn't know is that the family set up a third party or testamentary trust, one of the two, for the benefit of Johnny. But she wrote Johnny's name as the beneficiary directly. So these two trusts are up and living, waiting to get funded, and all of a sudden Aunt Ruth passes, and that money flies right over the trust and splashes into Johnny's pockets, making him over-resourced. Then we have to reach into Johnny's pockets and create a first-party supplemental needs trust. Why? Because Johnny is the one that has to grant the money to the trust. And because he is giving the money, it's coming from his Social Security number, it must go into a first-party trust. That's how these trusts get made by mistake. And we really would like to avoid that. And the reason why is this. At the death of Johnny, Medicaid has the right to collect against that lien in that trust. In this example, Aunt Ruth, California, left Johnny specifically as the beneficiary, even though other trusts were made for him. She didn't know that. So that money flew over the trust and splashed into Johnny's pockets. And in this case, Johnny passed 3 months after he received this money and that trust was set up. Johnny was 70. He had a very large Medicaid lien. And what happened, because this was a first-party trust, Medicaid came in and said, hey, Johnny has quite a bit of a Medicaid lien here. And because this is a first-party trust and because the trust was funded with Johnny's money from Johnny's Social Security number, we, Medicaid Social Services, have the right to take any money that's left in there. And in this case, Aunt Ruth's money didn't go to Johnny only for 3 months and did not go to the rest of the family. It went back to Medicaid. That's the mistake. Is it bad? Well, Medicaid is very important for a lot of our families, and it still needs to be funded. But that's something that could have been avoided. How could it have been avoided? One, if Aunt Ruth knew that there was a trust set up for Johnny, like the third party, and instead of naming Johnny the beneficiary, she named the trust for the benefit of Johnny, good. She herself could have set up a testamentary trust inside her will and said, upon my death, I want this trust to open up for the benefit of Johnny, and I want my money, instead of going to Johnny directly, to the trust for the benefit of Johnny. Now, another way a first-party trust gets set up is through lawsuit. And that means you might have a child that had a medical malpractice, an auto accident, something of that nature. They won the lawsuit and the money's coming in. So technically the money is in that child's pockets, that person's pockets, who are now disabled and now receiving SSI and Medicaid. Now we would set up a first-party supplemental needs trust because that means that we can protect the entitlements, the things that are paying for the care for that individual, and we can let that lawsuit money last a much farther time, longer time, to benefit the child. This is where courts and social services come in. They would have to approve the trust and have to approve the contribution to the trust. But we'd get it into the trust, it would get invested, it would be there for Johnny's well-being and used to pay for his support, stuff like that, things he needed. But remember, we don't give the money to Johnny, we pay for the goods and services. But at the death of Johnny, Medicaid has the right to go in and take what's ever left to satisfy their need or their lien. So, right or wrong, well, that was lawsuit money. It wasn't private family money like I just explained about Aunt Ruth. So, there's a little good and bad to this, but the biggest thing is plan. Understand what your tools are that are out there. Get counsel from good attorneys, good financial planners, and realize why you need a supplemental needs trust and the power of the supplemental needs trust. I think it's important to talk about what's probate and non-probate, because why is this so crucial? You want to fund the trust with non-probate assets. Easiest way to realize if you have a probate or a non-probate asset is to think about this. If a guy who has my job, a financial planner or the life insurance sales or what have you, turns to you and says the following: upon your death, who would you like to get this money? Right there, that's a non-probate asset. And the reason why is because you're able to list a beneficiary. So if you're a family that has a loved one or a child that has a disability and you've created a supplemental needs trust, this is the opportunity for you to write the name, social security number, the EIN number, I should say, and the title of the trust in as the beneficiary. It gets a little confusing. Some of the documents are a little, you got to read twice, and maybe you need help with. Come and talk to us. We'll be willing to help you with that. But this is where you would use the trust in place of the child with disabilities. Why? Because you want the trust to have the money, not the child with disabilities, because that money, if it goes into the pockets of the child with disabilities, it must go to a first-party trust. This is where you have the opportunity to name a testamentary trust or to name a third-party trust. You really don't want to use a first-party trust as a beneficiary designation. First-party trusts are created by mistake or because a child won a lawsuit. Examples of non-probate assets are life insurance, retirement accounts. You can have a joint bank or investment account, but you want to use the TOD or POD. TOD stands for transfer on death. POD stands for paid on death. That makes your bank account or your individual brokerage account a non-probate asset. If you don't do that and you individually own that asset, it becomes probate. Anytime you see a person with my job asking you that question, who would you like to leave this asset to? That makes it a non-probate asset. Probate, terrible? Well, first of all, we talked about a testamentary trust. And to set up a testamentary trust, you have to probate the will. So the will has to go through probate. What you want to avoid is have assets to go through probate. Probate means that it's going to have to stay in the account for a period of time, an estate account or a probate account. And that means that creditors can attach a lien to any of the assets that are in there for over 7 or 9 months here in the state of New York, County of Erie. So you really don't want to give creditors the opportunity to collect on this money. If you make it non-probate, it moves outside of that estate or probate account and directly to who or what trust you want it to go to. The kind of things you think about that end up in probate, a lot of times it's real estate and U.S. savings bonds. And the reason why is this. Mom and dad get older. They both own the house. Dad passes away. Mom owns it because she was a joint owner. No one does anything else with the titling of the house. Mom dies. That house now has to go into probate. It has to stay there for a period of time, and like again, you talk with the attorneys, it's somewhere between 7 and 9 months, depending on the county and the state you live in. However, when that house is in the estate account for that period of time, that's where creditors can attach to that house. What do you think the number one creditor would be attaching in my scenario where mom and dad owned it, dad died, mom went in a nursing home, then she died? Chances are it's Medicaid and social services going to grab the proceeds of the sale of mom's house because it's inside a probate estate and because they can attach to it because they're a creditor, and they're satisfying the lien that was created for when mom was in the nursing home. That's the story that, boy, that nursing home took a family home. No, it didn't. You paid back the Medicaid lien that gave mom her care in the last few years or months of her life. But you can avoid that by seeing an attorney and taking care of the titling of this property, either using a deed transfer or irrevocable trust or some type of trust. Please consult an attorney to get you through that. This is the example I just gave you about the assets of mom and dad owning the house. U.S. savings bonds pop up here for the fact that many times U.S. savings bonds are bought, but there is no identification of a POD on there. There's no further payment to, upon my death, paid to, paid on my death is what POD stands for. A lot of the savings bonds will come into our office, we'll look at them, we'll see who bought them and the social security number it's in, but you'll never see down below the registration POD. And that means it's a probate asset. And these are also the kind of things that get caught inside of a child with disabilities inside their Social Security number. Because maybe a godparent or mom or dad or a brother or sister bought a U.S. savings bond for the benefit of the child with disabilities, but it's in their Social Security number, and that thing matures, or there's multiple bonds. Suddenly, they're over-resourced with those bonds. So you want to keep an eye open for those. Those are the two big things. Take a look at the real estate and make sure the savings bonds have a POD. And then how you correct the rest is this. Many times when we work with our clients, what we'll do is we'll go over every asset they own. We'll identify the registration, which means is it a probate or is it a qualified or non-qualified, meaning is it a retirement account or is it a non-retirement account? And then we'll go through and identify who's the beneficiary. And many a times it's going to be husband to wife, wife to husband. But the contingent beneficiary is where we're going to focus. Because if you have a child with disabilities, you do not want to name that child with disabilities. You want to name the trust for the benefit of that child. That will protect their entitlements such as SSI and Medicaid. And you won't mistakenly open up a first-party trust. But there's something you must remember here. You have to have a car before you put gas in it. You have to have a trust before you can name it a beneficiary. Okay? So when clients come to visit with us, what we do is we find out all their assets, we understand who owns them, then we understand who's the beneficiary designation. Generally at that time we realize, hey, you have your son who's disabled on here, you really need to see an attorney to set up a third party or a testamentary trust. Once that trust is set up, come on back to us and we'll review your beneficiary designations again and help you understand where you have to add in the trust in place of your child with disabilities. That is crucial. Many times clients will see the attorney to set up the trust, but never correct the beneficiary designations. And what happens is mistakenly a first-party trust is opened up, and it could have been avoided just by following through to correct the beneficiary designations. Here's some other resources that I've leaned on. And again, I'm in the County of Erie, State of New York. This is going on our website, so I'm not quite sure who will be accessing it, so I want to be clear on that. One of the lawyers we work with quite often is Lisa Allen. Another one is out at Harris Beach, and another one's the Stams Law Firms. These are three that we have had quite a bit of interaction with. Hotchkiss and Russ is somebody that we've worked with before when we have to deal with Florida real estate and New York and multiple jurisdictions, multiple states. They seem to be very helpful. This is the Special Needs Alliance. I think is fantastic. If you have a child with disabilities or loved one with disabilities, I encourage you to go to their website, sign up, get their magazine. They have a lot of great articles. And the big thing they have is a national list of lawyers who work in this area, in this field. All right. Therefore, no matter where you're located, you might be able to get tuned in or turned on to an attorney that can help you with a lot of things we talked about. But it's also important to work with a financial planner that understands this stuff too, because many a times our relationships with the trustees go for many, many years to make sure the investments are handled right and distributions are handled right, all and the taxes fall into place and stuff like that. If you're in Western New York, there's a great thing called the Parent Network of Western New York. It's a clearinghouse for services. You can give them a ring, look them up online, get their phone number, and you can tell them your story. And they'll be able to tell you, hey, there's a workshop on this, or here's a great place to go for this, or here's a firm or an agency that can help you with that problem. And in New York, I've always leaned on the Developmental Disability Planning Council. They used to have a fantastic book called Planning for the Future, and that was published like back in the 90s, but it was very, very complete. And I'm finding a lot of that information now on their website. Also on this website, they have a lot of information for the New York State ABLE account, which is something we haven't talked about here, but is also another tool that you can use if your child with disabilities is over-resourced. I hope this was helpful. Please give us a call. If this is something that touches your life or friends or family's life, we've been doing this for a long time. So come on in, and it all starts with a conversation. Take care. Have a good day. Bye-bye.